Have you ever wondered how the court examines parties during a lawsuit? Let's delve into the world of legal proceedings and explore an integral part of it. Order 10 of the Code of Civil Procedure, often abbreviated as the CPC. This order plays a critical role in the court's examination of parties. So, what exactly is Order 10? Essentially, it's a set of rules that govern how the court interacts with the parties involved in a lawsuit. It outlines the procedures for the ascertainment of allegations, oral examination of parties, recording the substance of examination, and the consequences of a pleader's refusal or inability to answer material questions. Moreover, it paves the way for alternative dispute resolution, encouraging parties to seek settlement outside the court. It's fascinating how these procedures contribute to ensuring justice is served efficiently and effectively. Now that you have a basic understanding of what Order 10 is, let's delve into its specifics. First off, we have the ascertainment of allegations. Now this is where the court takes the initial step in understanding the case at hand. During the first hearing of the suit, the court directly interacts with each party or their pleader. The purpose: to ascertain whether they admit or deny the allegations of fact that have been made in the plaint or the written statement of the opposite party. This is a crucial stage as it helps in shaping the trajectory of the case. The court's aim here is to get a clear picture of the disputes that need to be resolved. This process allows for a transparent communication between the court and the parties involved, ensuring that the facts of the case are well understood from the get-go. So, that's how allegations are ascertained. Next, we move on to the oral examination. Now let's talk about the oral examination. This is a key aspect of Order 10 of the Code of Civil Procedure. During the course of a hearing, the court has the authority to orally examine any of the parties to the suit who appear in person or are present in court, but it doesn't stop there. The court can also examine anyone who is in a position to answer any material question relating to the suit. This could be an eyewitness, an expert in the field, or anyone else who holds relevant information. The goal here is to gather as much information as possible to aid in the fair and just resolution of the case at hand. This examination is not a one-way street. The parties have the right to respond, clarify, and present their perspectives. That's the oral examination. But what happens after the examination? After the oral examination, we move on to the next phase. Here, the court takes the substance of the examination and meticulously reduces it into writing. This isn't just a casual note-taking exercise, but a critical step in the legal proceedings. The judge's written record is a precise encapsulation of the examination, capturing the essence of the case. This written record becomes an integral part of the court proceedings, serving as a reference point for all future hearings. Now, imagine a pleader, for whatever reason, refuses or is unable to answer any material question relating to the suit. The court doesn't take this lightly. The hearing of the suit can be postponed to a future day, and the court may direct that such party appear in person on that day. This isn't just a simple delay. It's a consequential shift in the course of action, potentially impacting the outcome of the case. So, those are the consequences of refusal or inability of pleader to answer. Now let's discuss the final aspect. Finally, we have the alternative dispute resolution. This process comes into play after the court has recorded all admissions and denials from the parties involved. At this juncture, the court steps in and directs the parties to consider a path of resolution outside the traditional court setting. This could include methods such as mediation, arbitration, negotiation, or any other form of settlement as outlined in subsection 1 of Section 89. This alternative approach offers a more flexible, potentially less adversarial way of resolving disputes, and can often lead to quicker, more satisfactory outcomes for all parties involved. It is, however, crucial to remember that the court's role here is to guide and facilitate, not to enforce a particular mode of resolution. And that, folks, sums up the key aspects of Order 10 of the CPC. Remember, for a comprehensive understanding and application of this order, always consult a legal expert.